We are here from Victorian Legal Aid. We work on policy and law reform and strategic advocacy in our Family, Youth, Children's Law Directorate. I would also like to begin by acknowledging the Wurundjeri people of the Kulin Nation and pay my respects to elders past and present, and acknowledge that sovereignty was never ceded, always was and always will be Aboriginal land. Can you hear me? Okay, I have to lean in. And I also just want to take a minute to acknowledge the children and young people and their parents who spoke to us for our work. It took incredible strength for them to share their stories and experiences of the legal system, and we really wouldn't be able to do this work without them. Some of you may have seen this presentation or a variation of this presentation before. We've been working on it for a while. It is a challenge to work across different systems and do data analysis. We are hoping this research will be published before June, but we'll be in touch. So anyway, today we're going to take you through the kind of what, why and how we've done this research. And that includes overall trends we found in our data analysis for this cohort of young people. And then we're going to take you through our project findings and recommendations. So why we did this project is that actually you might know that Legal Aid provides lawyers around the state. So when we're talking about child respondents, our child protection and our youth crime lawyers provide duty lawyer services across Victoria. But the VLA also has, as part of its Legal Aid Act, part of the Act says that we should use innovative approaches necessary to reduce the need for one-on-one legal assistance and improve access to justice. And that's how kind of policy teams like mine work with our lawyers and our practice evidence to kind of advocate for change where we think that would have a positive benefit. And our lawyers have been telling us for some time that it felt like they were seeing more and more applications for intervention orders against quite young children in quite troubling circumstances. And so we sort of did a bit of a deeper dive, and just from our own VLA data, we see that there has been a 34% increase in total child respondents. So that's family violence intervention orders and personal safety intervention orders. And there's a really steep sort of rise, particularly for children and young people responding to personal safety intervention orders. I'm just going to hand over to Katie now, who's going to take you through our methodology. And apologies, we have to swap the little recorder mic thing.
Thank you. Thank you, and we'll get better at doing that. Oh, you've already clicked it. So for this project, we spoke to a handful of children and young people, as Alma mentioned, referred to us by in-house lawyers. And we also looked at VLA data, which is about 4,500 total number of young people responding to personal safety and intervention orders. And we looked at Children's Court publicly available data and family violence data dashboard, which is awesome. I'm sure you're familiar with it. And then to supplement our data analysis, we also looked at 50 closed VLA files, and we're continuing to do that file review, which has given us a bit more in-depth information about what is happening in these cases. And we've also been meeting with a range of stakeholders. So I just know that lots of people here probably are familiar with the intervention order system, but thought it would be useful to give you a really brief overview. So intervention orders are the civil legal response to family violence or serious stalking, although you can have a criminal case running at the same time. They aim to prevent people from using violence by putting certain conditions on them, asking them to stop doing or stop contacting someone. And if they don't follow the rules of that order, then they may be charged with a breach. We see, while there are similarities in intervention orders generally, there are some key differences in the way that the law treats children. So for personal safety intervention orders, the minimum age is 10, and that will be rising to 12 when the new Youth Justice Act begins later this year. However, and also there's a section in the Act that says the court may consider the child's ability to understand and follow the rules in the order, but there is no minimum age in the Family Violence Protection Act, and there is, although they can't be charged with a breach if they're older than 10, younger than 10, sorry, and there is no equivalent provision about their ability to understand the rules or understand the order. So this data is, statistics are based on our VLA case file data. It's pretty similar to what you would see in other research about youth justice, that children with disability, child protection and previous trauma experiences are overrepresented in the data. And I won't go through each one because it's up here, but come and have a chat to us if you've got any questions on the break. And I must apologise, we are lawyers, not mathematicians. This is 1 in 4 for those people who can do the maths, not us. So 1 in 4 young people with a disability is what we found in our review of case file data. And when we looked at our file review, you'll see that most of those young people reported to have neurodiversity, mental health issues or cognitive impairments, including intellectual disability. And this is difficult. Like, having a disability is sort of difficult for young people on intervention orders for 2 reasons. One is that often when we looked at the circumstances of the police being called or attending to a response, we could see that often it was could have been associated with that person's manifestation of their disability, but it is also makes it difficult for them to understand and comply with the order, which I'm sure everyone here is familiar with as well. And lastly, this does look a bit confusing, but bear with me. The top row is the oldest time, and the bottom row is 23, 24. And these are the number of finalised applications in the Children's Court over the last 6 years. The green represents final orders that have been made. And as you can see, that has gotten smaller. So the number of final orders being made is decreasing, whereas the pink section of the line represents those that have been withdrawn, and that has almost more than doubled over the last 6 years, from 19% to 47%. So what this suggests to us is that these IVOs are being made at times that might be in inappropriate circumstances, because there might be no further violence or no further contact with the young people who are parties to the order, or that the family didn't support the order, or that the child themselves couldn't comply with the rules stated in it. So I hand back over to Alma.
So these are the key findings that we've made. The first is that intervention orders are being used instead of supports for families in crisis. And I think as people who provide supports here, you probably are quite familiar with that. The second is that intervention orders are increasingly arising in schools and disrupting education, which is quite problematic. The third is that the intervention order system is not helping children or their families. And the fourth is that children are often left out of court processes. So I'm just going to run through a quite typical sort of scenario that we've seen, but one of the case studies and stories in our report, the story of Charlie, who's 15 years old, and Charlie lives in regional Victoria. Unfortunately, during the pandemic, when he was just 10, he started self-harming. A few years later, during a situation at home, Charlie's parents called the police after Charlie threatened to seriously self-harm. He was threatening to jump out a window, in fact, and they explained actually that it was a Sunday night. They just did not know who else they could call, so they did call the police. His parents were quite alarmed because despite their explicitly saying they didn't want any sort of legal action, police did apply for a family violence intervention order to protect Charlie's parents, with his dad named as the affected family member. And this was despite his parents really explicitly asking them not to. The court made an interim family violence order, which we see pretty often without Charlie or his dad at court. And police actually brought a copy of the interim order to Charlie's parents' house, and they were again pretty disappointed and shocked, in fact, and then were just told to go to court in the next 3 months. And they also made the point that they were told referrals to services would happen and that they'd be contacted by a service, and they said that just never happened, and they had to again keep advocating and get some supports in place. At the actual hearing, with the help of a VLA lawyer, the interim order was withdrawn. But I suppose this sort of scenario leads to this. This is a scenario that we've seen replicated, unfortunately, quite a lot. And that leads to our finding that intervention orders can be used instead of supports. And this quote from Charlie's dad, Luke, is quite powerful, I think. He was saying, like, the last thing I want is my son charged with a crime. They said they had no choice, which I found strange, and that it was totally counterproductive because what they really needed was some support. And many parents we've spoken to said they wouldn't call police again, unfortunately, after these situations, and that it feels really burdensome to be in the position of reporting breaches. And I guess that's why, hearing these sentiments, we are calling this research supported, not stuck, because kids have told us the process makes them feel stuck, but parents also feel stuck and hopeless. So that's why we decided to name the research, the report, that. And when we look at the family violence data dashboard from Crime Stats Victoria, it shows that police made 86% of family violence applications against children, which is higher than for adults. And as has been covered quite extensively here, but was quite shocking to me as a policy person, when we did our file review of these instances of family violence intervention orders, the most common reason for the actual dispute was about screen time and someone, switching off a phone or turning off an iPad. And as has been really well covered by the speakers today, it's really pretty shocking that these can eventually end up with an order being made against a child, often in circumstances where a child has a background of trauma or disability. And I think someone else noted that, often neurodiverse children can really self-soothe with technology as well. So it was just quite stark to see that these circumstances are resulting in orders. Another pretty telling and interesting statistic from the Family Violence Data Dashboard is that over 50% of child respondents have previously been listed as victim survivors on applications. So I think you'd all be familiar with that dynamic in this room, but it just feels like these orders are sometimes being applied for in pretty inappropriate circumstances. And I'm just going to pass back to Katie now.
Thank you. So I'm going to talk about another case study for Isaac, and this is a typical school-related personal safety intervention order. So Isaac has a fight with another student at the school after they were calling him names. And Isaac told us normally what happens is that the school does bring both parties together to try and sort it out, but unfortunately that didn't happen on this occasion. The other child's parent must have gone to police. Because we're acting for the respondent, we don't always know how these applications are making their way to court, but I'm not implying certainly that schools are telling parents to do this, but that's how anyone can make an application. So the child's parents must have gone to police, and police went to Isaac's house to issue him with a caution. 5 months later, Isaac received paperwork to go to court about a personal safety intervention order. So 5 months have passed, and during that time at school, he's had no further incidents with the other child. They've just been going to school as normal, and then they have to be drawn back into the dispute at a court. When they did go to court, the order or application was withdrawn after the lawyer said there's been no further incidents. I don't think this is necessary, and the court agreed. This has obviously led to our finding that PSIOs are arising in schools, and this is leading to disengagement. And this is a quote from Isaac himself, which, thinks it would have been better outside of court, doesn't feel like it's a matter that really should have come to the court in the first place. When we did our file review, we found 86, like a huge proportion of these IVOs are related to school disputes. That data is not public. This is based on our file review, which is a concern in itself, really, that the Department of Education or the Children's Court aren't publishing that data, actually. But our file review suggests that, yes, the proportion do relate to school. And half of these we saw were being made by the parents of the other child. PSOs are also having a significant impact on their access to school. So we saw kids either being expelled or suspended, or choosing themselves to not go to school. We reviewed one file where the student was paying for an Uber herself because she was afraid of getting the school bus and paying that out of her own money. So that is a real concern to us, because obviously we all know in this room how protective school is, and how, you know, disengagement from school can lead to this pathway of criminalisation as well. So I will hand back to Glenn.
Another case study. Amy is 14 years old and her mum Maggie spoke to us. They're First Nations. They lived quite regionally. Amy lives with multiple cognitive and behavioural diagnoses. And Maggie told us that as Amy, you know, got to adolescence, Maggie started to really struggle with helping Amy manage her behaviours and regulate her emotions. And Maggie told us that several times she tried to reach out for things like respite support. She already was engaged with child protection, but if she asked for greater support, she just said the existing services would tell her no, or they weren't available. And she felt she had no option. In one incident where Amy threatened property damage, Maggie made a really, must have been heartbreaking, incredibly awful decision as a First Nations mother to call police. And police came and put a family violence intervention order application against Amy. And over the next few months, we saw that Amy was charged with at least 6 breaches, which, as we've mentioned, can be quite serious criminal issues for pretty minor outbursts. And so, after, I think it was 6 months, her lawyers did get all of those, the intervention order and these breaches dropped, but it was quite a long process that actually did not result in Maggie and Amy getting the help they needed and that they had asked for several times. And it also did involve some quite distressing incidents of Amy, a really young, vulnerable First Nations girl, being, dragged into police vehicles and left there while police went and collected statements from the family. And it's really disturbing to us to see how the intervention order system can lead to the criminalisation of young people. And we see that in our data as well. And we really think it is a bit of an early pathway that is often downplayed because it starts off as civil. But we can see that, as it affects a really vulnerable cohort, these are directly leading to the criminalisation of children and families who need support. And we saw very few incidents in examples, through our file review of families actually linked in with either new support or even being linked into the existing support they already had through the intervention order process. So it just certainly doesn't seem like it is actually connecting families and kids to what they need. And one file we reviewed noted that supports for the young person were needed, but that there was a long wait list. And so for that reason only, the child was kept on an intervention order. So anyway, keep going. We could keep going. Thanks.
Okay, so this is the last case study that we'll share today. This is about Spencer. This is a personal safety intervention order occurring outside of school. Spencer was in a fight with another person, Chris. Chris and Spencer don't know each other. The only way they know each other is that the other boy had tried to steal Spencer's bike previously, a couple of weeks prior. But they were on a train, and on the train, Spencer told us that the other boy tried to pull a machete, actually, on him. So he fought back. After this incident, I think Spencer got off the train and went home, but he was charged with an assault by police. Even though, and he says this is totally unfair because he wasn't the one with the weapon. At court, VLA helped Spencer fight the assault charge, and the magistrate agreed to put him on diversion. But at court, the lawyer found out that he also had a personal safety intervention order made against him, but he had no idea. He wasn't at the court when the order was made, and that means he didn't have any legal advice or representation to, have his say. So when we spoke to Spencer, this is a great quote from him. Like, he doesn't really feel like it deserves to be on him, and it was kind of shit. And really like another add-on for him, particularly because he'd already been charged with an assault. This is really important, I think, for us. It made him feel really anxious and angry. Alma mentioned the title of our report is Stuck and Supported, Not Stuck. And he said when he had the intervention order and found out about it, he felt stuck. Like, he couldn't leave his house. He was really anxious about worrying that he might bump into this other boy around the local community. And again, as Alma has mentioned, we do hear that police, unfortunately, are telling our clients that they don't have to go to court to hear the PSIO or family violence intervention order application because it's just civil, unlike a criminal case. But as Spencer's story demonstrates, young people really want to have a say about their decisions that affect them. And this is from the family violence dashboard, the graph on the left, which shows that more than half of respondents to family violence, just family violence intervention orders, were not present during the hearing, which is huge. And when we looked at our own files, that was a very similar stat for both family violence and personal safety. And another thing that we found doing our file reviews and also speaking with the VLA lawyers who practice in this area, that the Personal Safety Intervention Order Act was actually introduced knowing that school disputes will take place, but really focused on putting them through a mediation process rather than a court process. However, there's been some funding changes post-COVID, machinery of government change, and that mediation is no longer occurring, unfortunately. So yeah, that's a real shame for these matters, because we also know that the personal safety intervention order doesn't teach kids conflict resolution skills at all. It is something they might not even understand and will probably continue to do the same thing. So that's a big difference for us.
And we're probably nearly at time or are at time, so I'll just quickly go through our recommendations. But we recommend 6 broad recommendations, including a mix of changes to the law and different service system and practice change. So the first is, of course, we would like the law in both Family Violence and the Personal Safety Act to change to ensure that intervention orders are not made against children, I guess similar to our broader calls for the minimum age of criminal responsibility to be raised, and are a last resort. So in strengthening and including those clauses that a magistrate really think about whether a young person can even understand the order. But of course, like ideally, I think we think many of these cases should not be in the justice system and really need a therapeutic response. So strengthening and resourcing the service system to support children and families to thrive. We did hear from our families and even kids themselves said sometimes when police arrived, that de-escalation could be helpful, and they did say there are instances where police will be called. So we are recommending changes to police practice, particularly around having like a child-centric risk assessment rather than an adult family violence risk assessment. We think that's pretty key, and hopefully exiting from a justice response unless there is an immediate danger. The fourth one is about trying to resource and equip schools and teachers to respond to issues arising at school. I think being in the justice system, we were kind of nervous almost about making sort of recommendations for the education system. And we only can work with our clients and see what's happening to them. But it does seem like there could be more kind of restorative justice processes and mediation processes arising in schools. And there are findings that have been supported also by the Victorian Ombudsman and the Commission for Children and Young People on that. We really would like tailored court responses for children and young people as they are entitled to, and the practice of kids being told they don't need to come to court really needs to end, and also trying to reinstate the processes of mediation through the intervention order, the personal safety intervention order process as it was intended. And six, and sorry, this was my oversight, but obviously our work is hugely following on from Elena Campbell and the Piper research into the legal response to adolescent violence. But we do think, we want this work that we're doing to hopefully have some flow-on effects with more research looking into intervention orders and into what we should be doing to help, particularly the school stuff, like kids resolve disputes earlier. And that's pretty much it. Do we have time for any questions, or is that? No, we do not have time. But please come talk to myself, Katie, and our colleague Hannah at any point today. But thank you so much.